Tēnā koutou, tēnā tātou katoa. I ngā mea o te motu I tatu nei, I tatu a Purangi. Ki tēnei o ngā wānanga, pāna ki te honga roia o Aotearoa nei. So welcome everyone to this webinar in which we will be discussing the recently completed report by the independent review, the report that is into the New Zealand Law Society. My name is Whaimutu Dius. I had the privilege of chairing the steering group which put together the terms of reference and recommendations on appointments to the panel. And we were pleased that we were able to find a group of people with breadth, depth, and diversity of experience and knowledge they could bring to this. So I will go straight now to introduce the people that you will be hearing from this afternoon. And this is in geographic order, starting with the tail of the fish. So we have Professor Ron Patterson, and he who chaired the review. We have Jane Mears, who is a barrister in Chambers based in Wellington, and we have Professor Jacinta Ruru, who is professor in Otago University, and we have Fraser Barton, who is the president of our Law Society, who is also privileged to be in Te Waiponamu. So we're going to go through. You'll see the format. We'll be going through the slides as each of the panel members will be speaking to those, as will our president. There will be time for questions. So please, we have had some questions submitted beforehand. If you have questions, go into the links on the links for this session. Put them in, and we will do our best to get through them to you and have them put to the panel. Nā reira, just a little bit of insurance, as my granny used to say. Kia whakaeria te tapu, kia mau mai te mauri ora, kia tūroki whakatahai, haume e hui e taiki. So just wishing us success in our endeavours and comfort and solace for those who are grieving and those who have suffered recently or a longer term. Okay, that's enough from me. So first of all, I've introduced the panel. We're going to put our first discussion point to the president of our Law Society, Fraser Barton. Kia ora.
Thank you, Waimutu, and tēnā koutou. So the first question is, why did the Law Society initiate this review? This decision predates my time as Law Society president, but I can speak to the various factors which led to it. Firstly, over time, it had been clear that the legislation, including the complaints process, was no longer fit for purpose and was not serving the public or the profession well. This was highlighted in 2018 with reports of sexual harassment within the legal profession. The legislative framework has meant that the Law Society is highly constrained in how it can address complaints and has not been able to function as a modern regulator. Secondly, the Lawyers and Conveyances Act, which was introduced in 2006, took about a decade to get to that point. So there was a feeling that the legislation was well behind the times and didn't reflect the changes that have occurred in Aotearoa and New Zealand. Alongside this, the Law Society needed to ensure that the legal profession has a strong representative voice that was responsive to the needs of the profession and the public. So there were things that we knew were not working as well as they should, in other areas such as being a regulator and a membership body in the same organisation where we were at risk of becoming an outlier in comparison to our international peers. So it was important to look at what was happening in other countries to see how we should be structuring ourselves. And of course, there have been many changes in our society in the meantime in terms of and the need for cultural competence in our diverse population and how to acknowledge te tiriti and how to promote innovation and competition in the delivery of legal services. This meant it was timely for the Law Society to put everything on the table. We commissioned this review to get an outside view and recommendations on what needed to change. And this is what the panel has provided. So over to you, Ron.
Tēnā koutou. So thank you, Fraser. And if we could have the next slide. So the review process, as we've just heard, started with a consultation with the profession from the steering group about the terms of reference, and the final terms of reference were very wide indeed. And we were appointed in December of 2021 or interviewed at least, and appointed to start the review on the 1st of March last year. And that slide shows us off on a race, and it has felt a bit like that. It's felt like a marathon at times. But it was pretty clear task that we were given was the framework that we had in our 2006 Act, was that still fit for purpose? It's interesting to look back at the legislation. Of course, it says in one of its purposes that it is to provide a more responsive regulatory framework. But the experience has been that it has not been as responsive as people hoped it would be. And so we approached it with an open mind. We went out in a discussion document that was widely circulated in the profession. In fact, I think people were being bombarded with law news every week, make a submission, and many did. So we had a survey response where you could simply, rate on, I think, on 1 to 5, but also people could make text box comments. So we heard from quite a large proportion of the profession that way, but then a lot of representative groups and individuals made email submissions, 183 of those, and we had all sorts of meetings with both special groups that were brought together, such as a group of standard lawyers from standards committees, a focus group of lay members from standards committees, and we met with various community and consumer groups, as well as with the community law centres Aotearoa, trying to get a sense of where the public might be, because it's very difficult in an issue like this to engage consumers. We looked internationally, and we took the opportunity when Jane was in the Northern Hemisphere, I joined her, and we met with leading regulators in London, in Dublin, Ireland, in Edinburgh, in Scotland. Our colleague Jacinta travelled to Canada to meet with law societies there and some leading Indigenous groups and the Federation of Law Societies, and I travelled to New South Wales, to Sydney, to the Legal Service Commissioner, and to Victoria. So we looked abroad to see how other comparable jurisdictions were handling this. And if we turn to the next slide. So on the 1st of March at our Supreme Court, I handed over our final report. 190 pages and a lot of in-depth coverage of the issues that we were charged with looking at it. In essence, it is divided into 3 parts: looking at the status quo, looking at how things work at the moment, then looking at the case for a new independent regulator, which was clearly the main issue that we needed to think about. And so we look at various models there. We also have several working papers, 11 in total, that are available on the panel website, as well as a cost-benefit analysis. So we thoroughly went through the case there, and then, having made our key recommendation, we looked at what would need to happen to implement that. And if we could turn to the next slide. So as everybody who's joined this webinar probably knows, the key recommendation is that we should proceed to have a new independent regulator. So the current model, which expressly provides that the New Zealand Law Society is both to be the regulator, but also to continue to be the representative body speaking out on behalf of lawyers. In our view, that is a compromise. It was recognised as a compromise at the time of the 2006 Act. And of course, at that time, there was a lot of change in the district law societies disbanding, with the exception of ADLS, and the formation of the new regulators. So there were all sorts of important changes in that Act. But if we now look at how it's working in practice, at what stakeholders tell us about that, we hear that there is a problem of perception that consumers, that clients, particularly those who then use the complaint system, feel that it's not, it's lawyers looking after lawyers, even though there's not good evidence to support that when you talk to members of the Standards Committee, that regulatory efficiency and effectiveness is undermined, and we go into some of the detail about that in the report, that the Law Society is somewhat muzzled in its ability to speak out forcefully as an advocate for lawyers, because it mustn't be, it's got to be seen to be the independent regulator at the same time. We looked, as Fraser has mentioned, the fact that New Zealand was becoming an outlier, and that we've now got quite a lot of history from jurisdictions that have moved to independent regulation, and how that has worked. And we also, as I've mentioned, looked at a cost-benefit analysis, which, somewhat to our surprise, that suggested that not only would this not be more expensive, but actually over time, there should in fact be savings from this model. Our model is very expensive on a per lawyer basis compared with some other jurisdictions. In terms of governance, we think there needs to be a change. All the presidents have said to us that former presidents, that the current board and council set up with all the good people who serve there is nonetheless an unwieldy setup. And we've said that a modern regulator would have a small board, about 8. They would be selected for their skills and competencies. We suggest there should be 4 lawyer members, 4 public members, and a public chair. And we say that because we think there needs to be a clear signal of a move from the past. And we recognise the importance of insulating the appointment process. This is not a Crown entity, it's a statutory body, and there needs to be a very careful process to make sure that that is not a political process, that people are appointed for their relevant competencies. And of course, there needs to be a strong national representative body for lawyers in this country that can speak up for issues, speak up for the rule of law, and we see the New Zealand Law Society well placed to continue in that role, indeed strengthened when that's solely its function. And I will pass to my colleague Jacinta.
O tēnā koutou katoa. If we can please turn to the next slide. So with this new regulator, we will need new law. And in our Chapter 7 of our report, we provide some draft purpose statements, a draft overarching objective, and some draft comments around the fundamental obligations for lawyers. So as we say in the opening to Chapter 7, at the heart of this reform ought to be recognising the public and consumers and acknowledge the importance of having a qualified, competent and independent legal profession. And these points are captured in our draft purpose statement. We've also recommended that all persons exercising powers under this Act should give effect to the principles of te tiriti o Waitangi. This is an important step to signal the importance of te tiriti to New Zealand's legal system and will guide how the regulator engages with the profession and the public. This could result in, for example, the regulator partnering with Te Hongaroia Māori and the delivery of certain functions, promoting the use of te reo and reflecting tikanga in its activities. We think it's important for the legislation to set out the objectives of the regulator. These objectives will provide clarity about the regulator's role and improve transparency in decision-making. The ultimate objective is to protect and promote the public interests. In achieving this objective, the regulator should have regard to 5 further points. 1, upholding the rule of law and facilitating the administration of justice. 2, improving access to justice and legal services. 3, promoting and protecting the interests of consumers. 4, promoting ethical conduct and the maintenance of professional competence, including cultural competence in the practice of law. And 5, encouraging an independent, strong, diverse and effective legal profession. We also recommended 2 material changes to the fundamental obligations on individual lawyers. So lawyers should be subject to an obligation to promote and protect the interests of their clients, subject to their overriding duties as an officer of the High Court. This is designed to emphasise the importance of lawyers working with their clients to achieve goals rather than simply protecting their interests. And secondly, lawyers should be required to maintain their competence and fitness to practice in their areas of practice. This change is important, we believe, to emphasise that every lawyer has a duty to maintain their professional and cultural competence to meet the needs of their clients. And you'll see at the end of Chapter 7, I would have went slightly further by adding 3 new regulatory objectives and 2 additional fundamental obligations for lawyers that I think are important for future-proofing Aotearoa New Zealand's legal profession. Next slide, please. But if I jump now to the next slide and into Chapter 11 of our report documents some of the ongoing cultural and conduct challenges within the profession. While the makeup of the profession has changed greatly in recent years, there are still significant barriers for many demographic groups, including gender equality, ethnic diversity, and social mobility. And the statistics tell a really stark story. For example, the past 30 years, there have been more female law graduates than male, but women make up only 61% of lawyers in law firms, but only 39% of partners. Asian, Māori and Pacific peoples comprise 40% of our population, but only 21% of the legal profession. And the pipeline into the profession is an issue, with a career in law not even a consideration for many. We also heard discrimination and racism remain a problem, and there are known issues regarding unacceptable conduct. The lack of diversity and exclusion of some groups, as well as addressing conduct issues, will not change without continued focus. And as we outline in our report, the regulator has a key role to play. More can be done, including by representative groups. We know our recommendations won't solve all issues, but they should help to make a difference. And so, as we've already discussed, and as will also be discussed in this webinar, the regulator will have a new objective to encourage an independent, strong, diverse and effective profession. There'll be an overarching Te Tiriti clause, there'll be diversity in the board, there'll be entity regulation and that freelance lawyer model. And our report identifies opportunities to remove some regulatory barriers to participation and progression, such as 1, remove the requirement to have a recently worked a minimum number of hours to be a sole practitioner, and this will benefit those wanting to become partners, barristers, or to work on their own account. And 2, admission and character requirements seen as exclusionary by some. Okay, so the Law Society publishes useful data on the makeup of the profession in its snapshot reports, but greater transparency is required. The regulator should require all firms to disclose data to it on the makeup of their firm so it can report on aggregate trends in the profession, and this is occurring in some other jurisdictions. We also recommend the regulator develop a mental health strategy and action plan. And as we list in our report, a number of programs and initiatives that have been adopted overseas to tackle issues with inclusion and diversity merit at least some discussion and maybe adoption here in Aotearoa, New Zealand. So next slide, please, and I'll turn now to Jane.
Tēnā koutou katoa. Thanks, Jacinta. So it's clear that there are many different ways to practice law, and the practice of law is evolving over time. So we've suggested that we need to, or that the profession needs to tailor the scope of legal services regulation. We received a number of submissions about extending the scope of regulation to cover currently unregulated services, and particularly about the harm that consumers are experiencing using non-lawyers such as employment advocates. But we didn't identify that the harm was widespread enough to justify bringing non-lawyers within the regulatory framework for lawyers. It still remains to be seen whether there should be some sort of other regulation for people who are providing legal services, acknowledging, of course, that there is no restriction on providing legal services in New Zealand. There are just restrictions on providing them in the reserved areas or in calling yourself a lawyer or a barrister or certain other titles. We also, we did, however, as Jacinta has mentioned already, propose that a new freelance lawyer model be introduced. And this is based broadly on a model which exists in England and which has been successful there, particularly in terms of broadening the profession and breaking down some of the barriers for people who want to return to the profession. So we're suggesting that lawyers should be free to provide services to the public without needing to be approved as a sole practitioner practicing on your own account, where the risk of consumer harm is low. And we think that if they're not operating in reserved areas, which is for example, litigation, and they aren't employing anybody and aren't handling client funds and are engaged by a client directly, that they should be able to have this freelance lawyer status. Currently, the requirements to be a sole practitioner include that you have done 2.5 years in the preceding 5 years of full-time work. And we heard very strongly that this is a significant issue for many people who want to return to the profession, particularly women. And we also heard that the current rules aren't necessarily working for clients because they do prohibit contracting arrangements. And many businesses want to employ lawyers to do short-term project work without necessarily needing to hire someone who's qualified as a sole practitioner. As many of you who are employed lawyers will know, there is currently a prohibition on employed lawyers providing pro bono services, and we heard very strongly through the process we undertook that many find that a very frustrating experience. For example, we heard from a general counsel from a large New Zealand firm expressing frustration that they would face disciplinary proceedings if they reviewed the most basic contract for a charity or a family member who needs legal assistance. And we heard from Māori lawyers who saw unmet legal demand within their communities, which they want to be able to help to address. So we think that prohibition should be lifted, and it's an area where regulation can be used to mitigate the risks rather than having an outright prohibition. And the gloss on that is that we thought that the pro bono services should be in the non-reserved areas, so that it's not a question of handling client funds or undertaking litigation. As regards corporate form, the Act imposes a couple of restrictions at the moment, and we think that new business arrangements should be permitted. The Act, at the moment, non-lawyers are prohibited from holding shares or being a director in a firm, and lawyers are prohibited from entering into partnership with non-lawyers, and we thought both these restrictions should be lifted. They are justified on the basis that a lawyer's professional duties might be compromised if they worked for someone who didn't share those same duties, but experience shows that the concerns are unfounded, and we looked at models from Victoria, New South Wales, Western Australia and England and Wales, and a lot of research that's been done over there, which, as I said, indicates that those concerns aren't founded. And consumers will, of course, be better off if lawyers have flexibility to choose their corporate form, because the current restrictions do limit the ability of law firms to grow, and it's hard for law firms to raise capital and make large-scale investments. And it also prohibits the one-stop shops, which are becoming prevalent overseas and that meet consumers' needs. And lastly, as I say on this slide, we think law firms in New Zealand should be directly regulated, and focusing regulation on individual lawyers fails to recognise that individual behaviour is often a reflection of wider cultural issues at a firm. Entity regulation is also becoming common overseas, and it tends to set outcomes for firms rather than compliance with prescriptive rules. And if we could go to the next slide, please. We thought it was time to place consumers at the heart of the regulatory framework, and we thought changes are needed to promote consumers' interest and shift the balance in the client-lawyer relationship, with an emphasis on consumer rights to good quality care and information, including about fees. We thought there were ways that the regulator should track client experience and consumer expectations and prioritise consumers' interests in its regulatory strategy, informed from advice by a consumer panel. We see a need for a much stronger focus on competence assurance in the regulation of lawyers as well. For example, fewer than 2% of lawyers in New Zealand generate 50% of complaints to the regulator, and the current regulatory framework treats instances of poor conduct as if they're random events, and they aren't. So this is about moving to a risk-based a system where the regulator can assess from a risk perspective where issues might be. Coupled with that, we wanted to shift the regulatory regime from a focus on addressing individual breaches to a model where the regulator could be more proactive in upholding competence in the profession and prevent consumer harm. And we recommend a package of new regulatory powers to help the regulator proactively identify at-risk lawyers and target support and resources before consumers are harmed, including such things as the power to suspend a practicing certificate pending the outcome of a disciplinary process where the regulator is satisfied the lawyer poses a risk of harm, the power to intervene without the need for a disciplinary or fault finding, when the concerns about a lawyer's fitness to practice arise, and that could include the power to direct a lawyer to undergo a health or competence review and to undertake further training, the ability to undertake practice reviews to monitor lawyer and firm compliance, and the ability to impose bespoke conditions on a practicing certificate, such as limiting the scope of practice. And lastly, in relation to CPD, there seems to be a fair level of consensus that CPD has become a bit of a tick box exercise and isn't necessarily ensuring that lawyers remain competent. England and Wales has recently moved away from a minimum number of hours approach to CPD, instead of which they now require lawyers to take the steps needed to remain competent in their practice areas. And we don't suggest that that happen now, but we think it's something that the new regulator should evaluate in due course. And we are recommending, however, that not all CPD activities need to be interactive or verifiable, and that lawyers should be trusted to do self-learning. And lastly, recommend that there should be some mandatory CPD components. We aren't mandating specific courses, but rather suggest that we follow the Victorian model, whereby the regulator can specify several core categories that lawyers need to do training in every 3 or 5 years. And this could include topics such as ethics, tikanga, te reo, mental health and well-being, unconscious bias, anti-bullying and harassment, and practice management, to name but a few. And I'll hand back to Ron now.
Thank you, Jane. And the next slide, complaints, a topic dear to every lawyer's heart. So the one area that we heard from so many members of the profession, 61% of the people who responded to the survey said we need to change the system. And on the complainant side, or the consumer side, a system that's achieving, I think, 27% of people satisfied with the outcome. It's something that ranks way below comparable systems for other professions. What are the problems? After all, this was a system that was intended to have a focus on complaint resolution, but unfortunately, a combination of the prescription in the Act, the way it's been interpreted in the Delu case in 2014, and perhaps lawyers, our own very nature in terms of disputing everything and making the process, effectively judicializing a process and turning it into a disciplinary system rather than a complaint resolution system. The standards committees are the key part of the current system. One would think that that's going to make it a cheaper system and perhaps a more efficient system. We've got capable lawyers who give their time. But what's happened in practice is that those committees need to be serviced by the Lawyers' Complaint Service, by staff of the Law Society. There's a lot of rework that occurs. There's agendas up to 6,000 pages, meeting notes and so forth. And it's not differentiating between matters that should be able to be resolved much more simply. And we believe that we should move to a professional in-house model, a model that's used in several jurisdictions, including successfully in Victoria, Australia, and now in Ireland, where the matters, if they relate to communication or to a bill or a matter that doesn't have any flavour of discipline about it, that the focus should be on sorting it out. And in the first instance, there should be a duty on each individual lawyer and on the firm to deal with the complaint promptly, fairly, and free of charge. Sort out our own complaints. And let's move from the current cumbersome, slow adversarial model to a model which enables the regulator to sift through the complaints promptly, and if in all the circumstances further action is not necessarily appropriate, to say that promptly, to consult about whether we should have a much tighter time frame. In England, they've introduced a 1-year time frame from when you knew or should reasonably have known about what's led to the complaint. So we're calling for wholesale reform. Moving from standards committees, there will no longer be a need for the legal complaints review officer because there'd be very few cases even leading to a determination of unsatisfactory conduct, and those cases could go to an external adjudicator, but not the full mechanism of the LCRO, which has laboured and worked so well under the current system, but at significant cost. Moving to the final slide from me. So next steps, Fraser's going to talk about the next steps in a moment. What I want to say for the panel is we've put a great deal of time and thought into this report. We strongly encourage you to read it. We realise that in terms of the detail that in the report, there are many areas where people will disagree. The focus at this stage needs to be on those high-level recommendations about whether it is time to move from the self-regulatory system with a little bit of co-regulation to have a true independent regulator, whether we should introduce and reform the complaint system and bring it in-house. And of course, we recognise that this will require not simply the Law Society to get behind the changes, but it's going to require political will. And at that point, I will hand over to Fraser. And as we say in the report, we've handed over our report, trusting that this once-in-a-generation opportunity will be seized. Kia ora. Thank you, Fraser.
Thank you, Ron. So now that the panel have delivered their report and recommendations, their work is done, and it's up to the Law Society now to take this forward. So I would stress that they are effectively functus officio, so there will be no further submissions made to them. Now, in deciding what to recommend, we'll be taking soundings from the 25-member council that represents the broader interests of the profession. Now, this council is made up of 13 branches throughout the country, so it's their presidents and the presidents and chairs of various sections and other related organisations that are part of the council. So every practitioner is represented through one of those bodies, so this is how you get your feedback through. And those branches and organisations are canvassing your views at the moment, and you may well have heard from them by now. I've also been travelling around the country, talking with lawyers and listening to their feedback. And I might add that no one's holding back on this. So the goal for us is to provide a response to the Minister of Justice before the end of the parliamentary term, which we expect will be at the end of July. This is the deadline if there is to be any possibility of getting this onto the legislative program for 2024. So, as you know, we'd previously asked the government for some interim changes to enable the Law Society to operate with greater transparency and efficiency, but this wasn't prioritised by the government and didn't happen. The review has given us compelling reasons to renew our push for the changes that we need, so we'll continue to talk with the government about the likelihood of legislative change. In the meantime, the Law Society we'll work on any areas that can be improved without legislation. And we haven't been sitting on our hands. We have been working on this over recent times with a regulatory strategy and working on the sustainability of the representative side of the business. And as you'll be aware, a couple of years ago, the changes to the rules, which reflected the recommendations of the Cartwright report. So we've been doing everything we can within the current legislative structure. So that's all I had to say. So I understand that Whaimutu has a list of questions that have been asked. So if I hand over to you, Whaimutu.
Good, Whaitha. It just so happens the first question is for you, sir. And the question is, what does the current president of the New Zealand Law Society think of the main recommendation and the recommendations, plural?
All right, thank you, Whaimutu. Look, a lot of the recommendations contained in this very lengthy report will be non-contentious. And others, there will be quite a range of opinions. The fundamental question, the most significant recommendation here, which is splitting off the regulatory into an independent body and then having representative separate. Look, in my view, there's a compelling logic to that. And it's not entirely surprising what the conclusion was. We are being constantly confronted on a day-to-day basis with the inherent conflict that sits with being in these two roles. So, as I say, there's a compelling logic to that. And there's a logic to most of the other recommendations. I would also suggest there's probably some that we'll be looking particularly for feedback from the profession, and there may be some tweaking needed, but overall, we welcome the recommendations, and particularly the most significant one. As I say, I think that it's pretty hard to argue against. Okay,
thank you. And for you, Ron, this is about the membership you referred to, in 4 members of the public and a chair of the new recommended body, and the chair also being a member of the public. And the question goes to the skill sets on which the members of the public will be selected and who does the selecting. I think so. Essentially, the question is, how will they be selected based on their skill sets? So there are a number of questions in there, but I've taken the liberty of pulling it apart. So the question is, how will they and how will their skill sets be determined?
So thank you for the question. So the first part of it is the skill sets, and the statute needs to make it clear that we're looking for people with competencies in governance, in understanding regulation of professions. I don't think everybody needs to be, even as a public member, to be familiar with the practice of law. What we've said is we think there should be two members who have at least 2 members with Te Ao Māori skills. But like any board for any modern entity, focus first on skills and governance, focus then on the relevant profession. And we think it's important. I mean, partly this is just about bringing in fresh ideas and perspectives. So moving from an election system, moving from solely lawyers to bring in that fresh air, other ideas. We haven't gone so far as the Legal Services Board in England and Wales, where every member has to be a non-lawyer. We think there is, importantly, a need for balance there, but we think having a non-lawyer or a public member as chair, which has been the experience in Victoria, has worked very well, and we think it would signal the change in direction that we think is needed.
And this is another question that's come up. I take it from that you believe that the risk that has been identified by the questioner, that skills and competence would be submersed by the need, by the push to have diversity. You think that balance would be struck?
Well, of course, diversity is important, and that will be one of the objectives of the regulator: a strong, independent, diverse, and effective board. So, yes, that is absolutely a relevant and important factor. And I didn't answer the other part of the question, which is how to insulate the process. We don't want to have something that's a politicized process. Lawyers are special in the sense that, yes, our role is to uphold the rule of law and to speak out in our democracy. But we don't think that will be endangered in having a careful, and we've gone into some detail in the report, to have a nominations process with relevant bodies, nominating people, doing that under the Ministry of Justice. And then if the minister wants to depart from that, that there would need to be, good reasons given, and those reasons to be published. And this sort of model in other jurisdictions, including in Victoria, Australia, has worked successfully and has prevented the process from being politicised.
I'm sorry to feel like you're being overworked in the questions, Ron, but a lot of them came out from the parts of the presentation that you spoke to, and sure. This goes to the fact of the two functions being separated, that is representative and regulator. And in addition to your comments and what the report says, and as well as in the working paper on the cost benefit, so what our president said about compelling logic, how closely did the panel actually look at the option of keeping the two functions together?
We looked very closely. I mean, we sat and we sat together and we said, is there any way that you can do this without having to force the two apart? And so we go through, I'm not sure whether I think it's chapter 5. We look at the options of having sort of a separate regulatory committee, which is what's being attempted in Scotland. Commentators there think it's ultimately doomed to failure. Some of the difficulty is just that the prescription in the Act, even to change the constitution of the law side at the moment, would require, changes to regulation and so forth. Long story short, we don't believe that anything short of what we've proposed would achieve what we're trying to achieve here in terms of truly making the two functions independent. So if you tried for more functional separation, then the Law Society itself admitted to us that that's very, very difficult for them in terms of making sure that they still have access to all the intelligence that the regulator needs to do its job properly. So you can read in detail the case that we make and decide for yourself, but we were compelled by the logic of moving and totally separating the regulator from the representative body.
Still on the question of the regulator, but I think this one is for you, Jacinta, and this is about the Law Society being able to function effectively as a guardian of the rule of law, if it is, I don't know, the actual question wording is, if it is reduced to a voluntary membership body deprived of its current funding source.
So apologies, Whaimutu. So the question is around the representative role?
No, is how is the Law Society? I think there's well, we can come back to what is implied, but the question is the Law Society's function. How will it be able to remain effective as a guardian of the rule of law if it is reduced to a voluntary membership body? Throwing this question to you because you had dealt with rule of law and the importance of it and being upheld in your presentation.
Well, just to comment and to reinforce the points that have already been made here by Ron and Fraser in particular, the New Zealand Law Society is an incredibly important entity for Aotearoa New Zealand, and for upholding that rule of law. And if there is a separation where the New Zealand Law Society becomes the representative body, that representative body of the New Zealand Law Society will be able to continue to speak freely and strongly on the rule of law without being hindered, I suppose, by that regulator role And so, we can see some real benefits there. Ron and Jane might want to add to that rule of law question.
I think I could add by just speaking to the experience in Victoria, where they're now sitting at 65% membership. So it is certainly the case that lawyers, when it's voluntary, will look and say, well, who's going to best serve our interests? And so there will be a challenge for the New Zealand Law Society to say, look, we're the national body, and yes, belong to Te Hongaroa, yes, belong to the New Zealand Bar Association, but we can bring something special and distinct. And other jurisdictions that have gone on this path, the representative body has been able to establish, show that it's got a value add for its members, and that they have chosen to continue to belong in sufficient numbers to ensure the viability of that national body.
Fraser, did you have your hand up? Yes, there you go.
Yes, if I could just chip in on that one too. I think it's a fair question that the rule of law will be a vital element with the representative side. So that's the Law Society going forward. That's going to be a really, really important role for it to play. And yes, with less funding, that is going to be a major challenge, and that's something that we've got to come to grips with. But at the moment, the Law Society has to ask the minister for sign-off on a number of things. And I do see an attraction in having a body, having a law society that doesn't have to bow and scrape and beg, and we can speak up really strongly independently. But to be able to do that, we're going to have a high level of membership, and we're going to have to resolve funding issues.
But just on that note then, Fraser, here's the question, more recent question just come in. What do you anticipate the process from here will be towards the new framework and legislation, and then in reality?
The process for the new framework, well, as I mentioned previously, we're getting the feedback. We will then communicate back to the minister, who already has the report. We'll communicate what the profession's views are on that, and then a decision will be made by the minister. And we're also going to be a little bit in the lap of the gods this year because there's an election, and that does create an element of uncertainty. And so that's why it's actually quite important that we don't sit on our hands, and that we continue. So the work needs to be started right now, or it has been started right now, for making sure that the representative division of the Law Society is sustainable and strong going forward. So that needs to be an ongoing work in progress. So does that answer that question, Whamutu?
I think so. And I think part of the message is that this is only part of a process. So people need to keep expressing their views and making them well known through their membership in society, as well as to their members of parliament as well, no doubt. But I'm going to switch a little bit now. There is a question here which I think we'll give to Jane. The person who has submitted it endorses the freelance lawyer recommendation, and however considers that there needs to be a lower minimum of the quality of education, such as 12 months rather than none at all. I mean, I'm not sure how you get 12's none, but anyway, the question is, you did mention thresholds and standards, Jane. Do you think we needed to have how much? And I know it's an ongoing issue. It will be an ongoing issue. We all know that. But how do you think we'll settle on that? What's the process?
I'm taking it that the question is about what the process is to entitle you to become a freelance lawyer.
Yes.
And I guess just reiterating what I said before, at the moment, if you want to contract in your own name, you have to be a sole practitioner, and that requires you to have 2.5 years in the last 5 years full-time work. Yep. I think that having proposed an independent regulator, our view is that the regulator needs to do some work to assess how they will approve, if that's the right word, someone to be a freelance lawyer. but that they should be looking at it in a much more holistic view than simply requiring people who practice in that sort of field at the moment to be sole practitioners. So in the same way that we talk about the need to assure competence in the report, that will be one of the things that the regulator will need to do. How will they assure the competence of that person? And I'm not necessarily suggesting that someone with as little, or didn't mean to suggest if that was taken, that someone with as little as a year's experience might become a freelance lawyer, but that the independent regulator will have to sit down and think about what are the minimum standards that will be required. I don't think freelance lawyers should necessarily, in fact, from a personal view, this is not something that as a panel we discussed, but I personally don't think someone should be entitled to be a freelance lawyer simply because they've been admitted, because they will have no practical experience whatsoever. So that there does need to be some standards, but if someone has, say, been practicing for 6 or 8 years and then decided to take some time off to have a family or to travel, when they return to New Zealand or decide they want to return to the paid workforce, the fact they've had a couple of years off should not prejudice them in the same way that it does currently. And some of the other some of the other things like not being in the reserved areas, not handling client money, I think will be important in landing on where the barrier is for those people to get that type of permission.
And addressing or applying appropriate thresholds. Yeah. So I think this one's for you, Jacinta. This is one of the written questions that's come in. How does the panel respond to critics such as the Aotearoa Legal Workers Union, who believe that the recommendations don't go far enough, particularly in addressing issues of overwork and burnout in the profession?
Yeah, this is a great question, and thank the Aotearoa Legal Workers Union for their submission to the panel and for their advocacy in this area. And they are important concerns. So we expect the regulator will need to address these issues because an important objective will be to protect and promote the public interest, by encouraging an independent, strong, diverse and effective legal profession. And strong must mean healthy, and effective, must mean to be able to work well. In relation to the paid overtime point, somewhere in our report, we note that Mind the Gap initiative, and that this is an issue that needs consistent response by the government across occupations and professions. And a progressive regulator, in concert with the representative bodies, should develop a mental health strategy. And I'm particularly reminded here of the incredible work by the Federation of the Law Societies of Canada, where late last year they released their first comprehensive national study on the wellness of legal professions in Canada over that period of 2020 to 2022. They surveyed 7,300 legal professionals, and that in all areas of practice and in all jurisdictions, legal professionals suffer from high levels of psychological distress, depression, anxiety, and burnout. It's a really significant report. Regulation can help make the shift, but not on its own. But it's with that cultural shift that so many of us agree is needed. So really value the work of the Aotearoa Legal Workers Union here and into the future for us as a legal profession. Kia ora, whai mutu.
Thank you, Owen. And for the question for raising it, and the Aotearoa Legal Workers Union. So, Jane, the question of libraries, and the question we have here is around the recommendation of the library becoming membership only. And so, a bit of insight here from it, and page 71 in particular, the cost savings is cited. Bit of insight, you're thinking of how this would actually work. Has the impact on scale and scope of the membership fee being calculated, and what level of service databases might be available on a different budget setup?
Thanks, Whanuitu. I think the first thing to say is that the libraries obviously provide a very valuable service to many in the profession, but we looked from a cost-benefit analysis at how the practicing fee was structured, and we also looked at recommendations which were made last time in terms of libraries, and that when I say last time, I mean when the current legislation was introduced, and that recommended that libraries should be a representative function, not a regulatory function. And when we looked at having, as I've said, recommended an independent regulator, when we looked at the split of functions between what was regulatory and what was representative, we felt very strongly that libraries were a representative, were part of the representative side of the Law Society. They're a membership benefit. And we recommended that they be a membership benefit, but how the Law Society in time works out how it funds them and how what services or databases they're going to subscribe to, or how one might access libraries, I think is something that the Law Society will have to work out. I guess for us it was about trying to institute a level of equality, if you like, between members, because there's many members who pay for all their own library and subscription services and books and so on and don't use the libraries at all. And conversely, there are a lot of people who don't have their own resources and use libraries exclusively, but there's no differentiation in terms of cost as to whether you use libraries extensively or not. So I think that's something that the Law Society would have to work out as a membership body, but basically our recommendation was that it isn't a regulatory function. Does that answer the question, Famutu?
Well, if we get a follow-up, we'll know, we'll see. I think it might have sparked a follow-up, but it certainly seemed to cover the question as it was put. Yes. We've still got questions coming in. Now I have one. There was a question about the online survey results being summarized and published. So this one I think might be yours, Ron. Now I think this is in addition to the parts of the report where you actually go through and state part one, survey question 41%, etc. Is there anything more that might be? Is it? I take it from our president. The panel's work is finished. So the short answer to this question is no. But how would you propose a person who is interested, perhaps in a bit more forensic information about what the participants said in their responses? How would they dig that out?
Well, I mean, we thought it very important to have the analysis of consultation submissions provided in a separate document. So that document has been prepared by SAPARE, the research group, the secretariat that supported us. There's a wealth of information there. It also needs to be said that that was just an input for us. So we didn't regard all this as a numbers game. We were interested in the arguments that people made. We gave particular weight to representative submissions, some of those representing hundreds and thousands of lawyers. But yes, for those who want to look at the forensic detail, there's a lot of information in that supporting document, which is available on the panel's website.
Thank you. Just while we have you, you did refer to the numerical balance, I think was your word, in relation to the composition of the board. And the questioner has said, if it was good enough for the Medical Council to only have 2 lay members out of 11, why are we going for a higher one here?
Well, it's true, but then I think lawyers like to be leaders, and just because every other profession in New Zealand has rather timidly gone with sort of 2 out of 8, internationally that's not the trend, and I think we have the opportunity to do things differently. So I don't think it should be a question of simply following what the Medical Council has done.
Okay, just make sure now we got. That's making sure. I'm just, bear with me, folks who are on the webinar. All your questions have been supplied. We've been going through them. I want to make sure I haven't missed any. that weren't already answered. There was one question which was who on the panel has got previous experience with professional regulation. I think that means as an applicator as opposed to going through it. But I think Ron, you maybe I know you do. Do you want to talk about that and how that expertise was applied to the work of the panel?
Well, I think there's two aspects. There's who's actually worked as a regulator. And I'm probably and Jane as well. Health and Disability Commissioner is not exactly a regulator, but it's quasi-regulatory. Certainly in my academic work, I've done a great deal of work in how we regulate professions. We've all tried to bring those skills, our different skills, to this review. And now others are getting to pick over the details of our report and to consider what we've recommended.
Yes, no, and I think the distinction in the two parts of that function is well made. There's a question that's come through, or a couple that questions, Fraser, that request that perhaps are you able to clarify just what what the practicing fee pay currently covers?
Yes, the practicing fee only goes for regulatory. So that's and there's various subsets of that components, and I haven't got the detail in front of me, but it can only pay for the regulatory, and that's the Act prohibits any cross-subsidising, so it does not pay for anything to do with representative. So that's one of the issues we have at the moment in terms of financial sustainability of representative.
Okay, all right. Now we're starting to get back into the pros and cons, I think, as opposed of combined versus separation. But here's a question which I may not be take very long to answer, but I think this is yours as well, Ron. Did you consider a regulatory model where the Law Society continued to be the regulator but stopped providing representative services?
Yes, we did, and that is a model that Canada has. We heard from commentators about how that's worked out in practice, and we think it's better to this is the time for separation, and we see the most valuable future role for the Law Society in being the national representative body.
Okay. And Jane, won't allowing non-lawyers invest in law firms mean that the legal profession becomes corporatized and just encouraged to focus on profits as opposed to professional legal standards and ethics?
Well, the evidence from overseas is not that does not show that there's been a problem, and some people would say that the large law firms, particularly, of which I used to be a partner at one, focus significantly on profits, and they are corporatized entities. So I'm not convinced that we'll go down a slippery slope on this. Lawyers who remain in those firms still will have their fundamental obligations to uphold the rule of law and their professional standards, and that doesn't stop simply because they're operating in a model where they might be able to get access capital from entities or groups other than lawyers to develop their systems and processes. But yes, I mean it is entirely possible that some will become more corporatized, but I don't accept on the evidence I've seen that it means that it will inevitably mean a lowering of standards.
Okay. All right. And we still have a couple of minutes if you want to keep firing in the questions. But we are looking to wind up in 6 minutes, and the team we have running it is is very attentive to detail. So now's your opportunity to, if I've missed asking a question, then restate it again, and I'll apologize in advance. But I think we've got them all, and there is one. I'm going to come back to terms of reference, Fraser. A couple of comments have been made about them being wide terms of reference, and we've talked about the logic and the compelling nature of it in the recommendation. But why did the Law Society go so wide?
Well, I mentioned previously the scope of the problems that we were recognising, and that the legislation we thought was not fit for purpose, that we were suffering from a whole lot of constraints, and that rather than looking at this in a piecemeal way, the whole picture needed to be looked at, and with no sort of preconceptions, and indeed it was possible someone independent might look at it and say, well, actually that compared to anywhere else in the world, that works pretty well. So we as I say, we didn't have any preconceptions, and it was felt that it was better to have everything on the table and to look at it that way. So that was the answer.
Okay, all right, thank you. All right, I think that's probably a good way to end it all too. Well, almost. So, Ron, I'm just going to give you one final comment as the chair of the group that's provided us with such a thought-provoking, I won't say provocative, such a thought-provoking set of recommendations. So, what's your final word on this?
I just want to say thank you. Thank you to the Law Society, to Fraser and his predecessors, and to Katie Rustach, the Chief Executive, both for the privilege of undertaking the review and also for the way in which you opened the books to us. Nothing's been held back, and that's been very helpful for our process. And I just want to thank my wonderful colleagues, Jacinta and Jane. We've worked together as a team, and now we've handed it over, and we strongly encourage everybody to read the report. If not the report, read the executive summary, and we wish you well in your deliberations, and we hope with time that this will lead to change.
Thank you, Ron. And so it's up to me to now close. I started with some encouragements from my nanny. I finished it. She used to say, if you don't ask a question, you don't be surprised if it doesn't get heard. So please, everybody who's been on here or is still here, just make sure that if there is anything you want to know, or comments you want to, views you want to provide, put them in, because they all will contribute to the quality of the final product. So I'll just close by asking our forebears and the celestial beings to continue to give us their guidance and to continue to look after us and our whānau. Nā reira, kia tau te Māori, kia tau te rangi Māori e, hui e, tā ki e. Thank you, everyone.